the written answer to question 120 of 2021 lodged by the Connétable of St Martin to the Minister for Economic Development, Tourism, Sport and Culture. The question is requiring information under 4 separate headings, and in my view, having reviewed the answer, it cannot be said that the answers are not relevant and do not address the question, and therefore I rule that the answer is in order. Very well, we now come on to public business, but before we start public business, proper decisions will need to be made by the Assembly whether or not to reduce the lodging period in respect of 3 matters listed on the order paper for delay of this session. There are 2 amendments, I think, by the Corporate Services Scrutiny Panel in relation to draft income tax payment of 2019 liability regulations P9. Senator Moore, do you wish to make the proposition under Standing Order 26(7) that the lodging periods be reduced to allow them to be debated at this sitting? Senator?
Thank you, sir. I would be very grateful if members would allow the raising of this lodging period. We made our very best efforts to present the amendments within the allocated time period, but actually due to some internal delays, particularly hearing back from Treasury and Resources Department, it wasn't possible to get them published in time, so I apologise for that.
Well, is that seconded?
Yes, sir.
Does any member wish to speak? No member indicates a wish to speak. Then I propose to take this on a standing vote. If anyone wishes for a formal vote to be taken, then we can do that. But otherwise, please indicate in the chat if anyone wishes to vote contre. Otherwise, I'll take it as adopted on a standing vote. Very well, I will take that as adopted on a standing vote, and the Assembly has agreed to take those items. The last is the application by the President of the Scrutiny Liaison Committee to propose the minimum lodging period in respect of land transaction under Standing Order 1638 Office Accommodation Project Union Streets in Helier. Deferral of approval P18 be taken. Senator Moore, this is your proposition as well, I believe.
Yes, sir, it is, and I have to say apologies, I was confused in the last request. It was this request where we were particularly delayed due to waiting for information from the Treasury and Exchequer Department. However, in this instance, that didn't bear too much of an impact because we are in any event way ahead of the regular lodging period for this proposition, but we are doing so at the request of the Chief Minister, who is keen to progress the debate.
Well, is this seconded, this request to the Assembly?
Yes, sir.
Yes,
Does any member wish to speak? No member wishes to speak, then as for the last one, I'll take this on as a standing vote. If anyone wishes to put the vote for the appel, please indicate now. Otherwise, I will take it as an adoption on a standing vote. Very well, then I will take this as adopted on a standing vote, and that matter can be dealt with as well. We now come on to the first item of public business, which is the secondary employment of public sector employees review of policies P146 lodged by Deputy Masson. I ask the greffier to read the proposition.
States are asked to decide whether their opinion, A, to request the State's Employment Board in conjunction. Sorry about that. A, to request the State's Employment Board in conjunction with the Council of Ministers to review the existing rules, policies and guidance relating to the ability of public sector workers to secure or hold employment that is secondary or additional to their employment with the State of Jersey. B, that the review should include input from all States members and other relevant stakeholders. C, that the review should be concluded within 3 months of the adoption of this proposition. And D, to request the State's Employment Board, once the review has been completed, to lodge the rules, policies and guidance for debate and approval by the States Assembly no later than 6 months following the adoption of this proposition.
Thank you, sir. And I'd just like to begin by thanking members of SEB and the officers supporting that particular committee, because behind the scenes there has been a lot of work, and I know members who attended the presentation yesterday that looked at that was given a presentation about the work that had been going on, the changes in policy, the enhanced, that's what I'm looking for, enhanced procedures around standards in public life that are out to consultation, and indeed at that presentation members were offered, if they wanted to take part of that consultation, to contact SEB in order to participate and give views on the consultation that has been launched. So therefore, sir, in effect, my proposition has already been met. So therefore, sir, I don't feel the need to proceed with this debate. I'd just like to thank members and officers for their support in resolving this matter, and so I'd like to withdraw this proposition.
You wish to withdraw the proposition? Well, you're entitled to do so before the debate is opened at any point. Therefore, the proposition is withdrawn. Very well. The next item of public business is the draft States of Jersey Amendment number 9 law, P3, lodged by the Privileges and Procedures Committee, and I ask the greffier to read the citation.
Draft States of Jersey Amendment number 9 Law 2000, a law to amend further the States of Jersey Law 2005 to make provision for parliamentary privilege and connected purposes. States subject to the sanction of a more excellent Majesty and Council have adopted the following law.
Is someone stepping in for Deputy Alves? Senator Valois, are you doing the proposition?
Yes, sir. As Vice Chair of PPC, I've been asked to take this proposition today.
Yes, very well.
Yes, thank you, sir. So this is a short but important piece of legislation which modernises and improves the system of parliamentary privilege in Jersey. Parliamentary privilege is the term for the rules which uphold the special constitutional status of parliamentary bodies, reflecting their democratic accountability to the electorate. There are two key aspects of parliamentary privilege. One is the principle of freedom of speech for parliamentarians and other people who contribute to parliamentary proceedings. The other is the legislature's freedom to set its own internal rules and procedures. Without effective rules on parliamentary privilege, legislatures and their members risk facing legal challenges because of the things they publish, say and do in the course of their parliamentary work. PPC has been reviewing the law on parliamentary privilege since 2016. In 2016, the then Chairman's Committee drew attention to defects in the drafting of the current law, which could permit legal action to be brought against people because of evidence given to scrutiny panels. The greffier of the States also drew the committee's attention to other technical problems with the law. The Attorney General has subsequently observed that the legislation on parliamentary privilege does not cover scrutiny review panels, which is another gap to be remedied. PPC commissioned Sir Malcolm Jack, a world expert on the subject, to review parliamentary privilege in Jersey and to make recommendations for improvement. His report was published in 2017, and his recommendations formed the basis for the draft law in front of us today. The draft law amends the existing primary legislation on parliamentary privilege. Based on a definition of states proceedings, this closes the various legal loopholes previously identified. There is a clear statement of the circumstances in which states material, such as Hansard, can be used in legal proceedings, clearing up an area of legal ambiguity. In particular, states material cannot be challenged or questioned in court and cannot be used to invite inferences or conclusions to be drawn. This is crucial to avoid political disputes being dragged into court and to protect freedom of speech in the Assembly. While most of the law modernises or clarifies legal provisions which already exist, there is one new legal right contained in Article 4. This deals with members' correspondence with the public and was recommended by Sir Malcolm Jack, drawing on Australian legislation. Members' correspondence with the public is not automatically protected by parliamentary privilege, as it might not relate to states proceedings, such as a debate or a question. Article 4 provides for correspondence with the public to be protected from defamation proceedings, unless it is shown to be made with malice, and if the communication is made by an elected member, acting in his or her capacity as an elected member. This is an important protection for members' work as constituency or parish representatives. The other provisions in this draft law mostly update or clarify existing rules. One exception is in the changes to Article 48 of the States of Jersey law, which deals with the Assembly's standing orders. The draft law inserts a clear statement into the law that matters to do with the standing orders cannot be brought before a court, reinforcing case law going back at least 20 years. The draft law also recognises that the standing orders should not be on the same footing as statute law, although this technical change won't affect how the standing orders operate in the Assembly. This legislation is an important piece of housekeeping which PPC has worked on for some years. Given the complexity of the subject, we have been fortunate to have at our disposal the advice of Sir Malcolm Jack and his knowledge of how parliamentary privilege works across the Commonwealth. These changes strengthen our democratic system in small but important ways. Sir, I maintain the principles.
Are the principles seconded?
Yes, sir.
Does any member wish to speak on the principles? If no member wishes to speak on the principles, then I close the debate and I ask the greffier to place a vote into the voting link. Yes, it'll just be a few moments. There's a slight technical glitch, but it'll be there very shortly. Would nobody please seek to vote yet, because the link's not yet been placed into the voting box, into the chat. I remain cautiously optimistic that the link will be in the chat fairly shortly. And the link is in the chat. Accordingly, I open the voting and ask members to vote. The vote is on the principles of the amendment to standing orders. Deputy Morell, I will disregard your vote because it came before the voting was opened. So if you feel the need to vote in the chat as opposed to on the link, please do vote again. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The principles have been adopted, 40 votes pour, no votes contre, no abstention in the link, and 2 further votes pour in the chat. Senator Moore, does your panel wish to scrutinise the matter? Corporate services?
No, thank you.
Thank you very much indeed. Then Senator Valois, how do you wish to deal with the articles in second reading? There are 12 articles in all.
So if I may take them on block.
Yes, by all means. Did you wish to speak to them?
No, I think they're fairly self-explanatory. I tried to explain mostly what they do in the opening principles, but if anybody's got any specific questions on any particular article, then please feel free to question those. So I maintain the articles en bloc, sir.
Are they seconded in second reading?
Yes, sir.
Does any member wish to speak on the articles in second reading, or any of them? No member wishes to speak. Then I close the debate and ask the greffier to put a vote into the link. And I open the voting and ask members to vote. Members have had the opportunity of casting their votes. I ask the greffier to close the voting. The article's been adopted in second reading, 40 votes for, no votes contra, no abstentions. You propose the draft in third reading, Senator Valwa.
Yes, please. So if I may just at this stage say thank you to members for supporting this legislation. Thank you to members and officers that have worked for a few years bringing this forward for us, and also for Sir Malcolm Jack's report around supporting parliamentary privilege. It's a welcome change to the law, small but important. Thank you, sir.
Right, Senator, is the matter seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? Deputy Higgins.
Yes, thank you, sir. I'd just like again to express my thanks to the greffier, Mark Egan and his staff, as well as all the others who've been involved in this. This reform is long overdue and much needed. And for the benefit of the public who are thinking, gosh, are the states voting on something else again without even debating it? The truth of the matter is there have been talks behind the scenes and briefings, and I think any questions we wanted were answered at that time. So it's a welcome reform, and that's why there's been no debate on this. But thank you, sir.
Thank you very much, Deputy. Does any other member wish to speak in third reading? If no other member wishes to speak in third reading, then I close the debate and call upon Senator Valwa to respond.
Thank you, sir. Just thank Deputy Higgins for his contribution, and he's added thanks to the staff, particularly in the GREF, for bringing this forward with PPC. And of course, if anybody's interested, as Deputy Higgins has mentioned, although there's been no debate as such, there is an extensive report and the information is gleaned in there. But I thank all members for their support and maintain the third reading, sir.
Well, I'll ask the greffier to place a vote in the voting link. And I open the voting and ask members to vote. If members have had the opportunity of casting their votes, then I close the voting. And the legislation is adopted in the third reading, 40 votes for, no votes contra, no abstention in the link, and a further 2 votes for recorded in the chat. Well, we now move to the next item of public business, which is the draft road traffic number 65 Jersey regulations lodged by the Minister for Infrastructure. For the purposes of this debate, the chair of the Environment, Housing and Infrastructure Scrutiny Panel will be the main responder, and I'll ask the greffier to read the citation.
Draft road traffic number 65 Jersey regulations 2000. The states make these regulations under the Order in Council of 26 December 1851 and Article 92 of the Road Traffic Jersey Law 1956.
Minister.
Thank you, sir. Sir, I wish to begin by commending the officers from Driving and Vehicle Standards for consulting widely across government departments and with the Comité de Connétable, scrutiny, medical professionals and charities to draft this amendment of the Road Traffic Jersey Law 1956. Updating and improving our road traffic legislation contributes to improved road safety. This amendment aims to align our medical standards with UK requirements to ensure consistency for issuing authorities and medical professionals. It will also ensure that our standards comply with EU Directive 2006/126/EC on driving licenses. In formulating the draft amendment to the Motor Vehicles Driving Licenses Jersey Order 2003, it became necessary to firstly make amendments by regulation to the primary legislation. So all proposed changes to these regulations are contained within the report, but here are the key amendments. Regulation 2 inserts medical condition to replace disease or physical disability currently used in the law. Regulation 3 reduces the period of validity of licenses that are granted to applicants between the ages of 45 and 66 who wish to drive certain prescribed categories of vehicle. The period of validity is reduced from 10 years to 5 years, or if earlier, when the license holder reaches 66 years of age. The intention is that the order will be amended to include goods vehicles over 3.5 tons and minibuses. Regulation 4 substitutes Article 9 of the law in relation to the procedure that apply if an applicant for a driving license has a medical condition by broadening and simplifying the powers of the parish. The substituted Article 9 gives the parish a new power to require an applicant to undergo a practical driving assessment in addition to or instead of a medical examination, and wider powers to impose appropriate conditions on a driving license if required. Such conditions can include requiring further examination or assessment after the license is granted, and except in the case of a provisional license, limiting the period of time a license remains in force, so it expires earlier than it otherwise would under Article 4. The substituted Article 9 retains the current provision in the law that a parish must refuse to grant a license if a person suffers from a medical condition prescribed by order, unless the person meets any requirements prescribed by order for controlling that condition. Regulation 5 substitutes Article 10 of the law in relation to the procedure that apply if a holder of a license has a medical condition. It does not apply in the case of a provisional license holder with a medical condition to the extent that Article 9 applies. Article 10, like the substituted Article 9, broadens the power of a parish to require a license holder with a medical condition to undergo a practical driving assessment in order to, or instead of, a medical examination, and to impose appropriate conditions on a driving license, including further examinations or assessments. There are also powers to revoke a licence if the parish would be required to refuse a licence under Article 9 if the licence holder were an applicant, and to suspend the licence if it appears that a licence holder will suffer a medical condition for a limited period of time. So upon acceptance of the regulation amendments by the Assembly, the proposed amending order set out in full in the report will be approved and signed, and another order will be signed to bring the regulation into force at the same time. Approval of the amending order is planned for the end of September, that being 6 months from today, which will be for the appropriate changes to be made to the driver licensing system and supporting paperwork and the necessary public communication to be undertaken. So I will end by thanking the Comité de Connétable and the Scrutiny Committee for their constructive feedback, and to ask all stakes members to support this proposition and build on our commitment to improving road safety. I make the proposition, sir.
Proposition seconded.
Yes, sir.
Oh, the principal seconded, I should say. Yes. Does any member wish to speak on the principles? Connétable of St Brelade.
Thank you, sir. The panel is pleased to receive a presentation from officers of the department with regard to the updating of this law, and the comments we've provided from them, I hope, are comprehensive and will assist in making their decision. I'd like just to raise a couple of points from those comments, and firstly, with regard to the question of diabetes, which members will note in the proposition has changed with the new. Whilst I see that the Minister has laid out changes, the panel considers it important to put some guidelines down.
Sorry, sir, to interrupt, but the deputy is very faint. The sound is very.
Connétable, yes. Connétable, you were fairly faint. I could hear you, but perhaps others can't. I wonder if
Connétable, sorry. Connétable, sir, I'm sorry.
Yes, I wonder if you.
The microphone, sir. The panel felt that the question of diabetes would require some guidelines to be available at parish hall counters, so that prospective drivers or licence holders will have a clear indication of what is necessary. With regard to the life of the licence, there was a question over the reduction of it and a question of reducing the licence fee. We do understand, so that the predominant cost of the licence is its initial issue by virtue of administration and production costs, so the ability to reduce those costs may be limited. The other,
I'm afraid, Connétable, you've now gone almost entirely silent.
oh my goodness, how's that, sir?
Well, okay, but you are still quite faint.
Right, I shall come yet even closer to the microphone, and the hope, sir, is that the panel looked at the self-declaration issue of medical conditions, and were concerned that those would be declared honestly, and whether the fine levels which would be applicable would sharpen people's minds when it came to that. And that is outlined, sir, on the last page of our comments in the panel.
Connétable, I'm sorry to interrupt you once again, but members, or at least one member, is indicating an inability to hear you, and it is quite faint. I can hear just about if I'm listening carefully, but it could be that others cannot.
Well, sir, I've just finished, and I refer to the penultimate paragraph of our comments where the fine levels are mentioned, and I would conclude in supporting the Minister's proposals, and look forward to the debate, sir. Thank you.
Thank you very much indeed, Connétable. Does any other member wish to speak on the principles? No other member wishes to speak on the principles? I close the debate and call upon the Minister to respond.
Thank you, sir. And I thank once again the scrutiny panel and indeed the commentator CONITAB for their sound advice and indeed their support. The constables just mentioned diabetes 1 and 2. I take those comments on board and I will forward that back to the team. Although it's marvellous that nowadays with modern medicine, both diabetes 1 and 2 are much better controlled as in the old days. License fee, as the constables mentioned, most of the fee involved is to do with processing. So I'm not sure if that can be reduced, but obviously we will look into that. And regarding declaration, there is a fine for making a false declaration, which the constable has pointed out. If there's a genuine error, obviously that's taken in consideration. But if there's a deliberate a false declaration, that would be an offence with punishable by fine. I thank them again for their support, sir, and I make the proposition again, sir, in the second reading.
Very well, I will ask. No, it's not second reading. We are adopting or not the principle. Right. First reading. Then,
ask for the approach, sir.
I'd ask the greffier to place a link into the chat. And I open the voting and ask members to vote. Members have had the opportunity of casting their votes. I ask the greffier to close the voting. Principles have been adopted, 44 votes pour, no votes contre, no abstentions. And I assume from what you said, Conatapis and Prahlad, your scrutiny panel does not wish to scrutinise the matter?
That is correct, sir.
Okay. How do you wish to propose the regulations, all 7 of them, in second reading, Liz?
In block, sir.
Do you wish to speak to them or merely answer questions on them?
More than happy to answer questions, sir.
Are they seconded in second reading?
Yes, sir.
Does any member wish to speak in second reading? No member wishes to speak in second reading? Then I close the debate and ask for the greffier to place a vote into the link. And I open the voting and ask members to vote in the normal way. If members have had the opportunity of casting their votes, I ask the greffier to close the voting. The articles have been adopted in second reading, 41 votes pour, no votes contre, no abstention in the link, and a further 1 vote pour in the chat. Do you wish to propose the matter in third reading, Minister?
Yes, please, sir.
Does the matter seconded in third reading?
Yes, sir.
Any member wish to speak in third reading? If no member wishes to speak in third reading, Conor St Brelard.
Just briefly, sir, to thank the officers for their presentation on P6, which was very helpful, and to thank the Minister for moving this through, which is a much needed update of the legislation. Thank you, sir.
Does any other member wish to speak in third reading? No other member wishes to speak in third reading. Then I close the debate and call upon the Minister to respond.
Thank you, sir. I'd just like to thank the Constable for his kind words, and both scrutiny and the Committee of Conor for their support, and indeed members for their support for this long overdue update of the safety regulations. And ask for the appel, please, sir.
That is called for. I ask the greffier to place a link into the chat. And I open the voting. If members have had the opportunity of casting their votes, I ask the greffier to close the voting. The regulations are adopted in third reading, 43 votes for, no votes contra, no abstentions. Very well, we now come to the draft termination of pregnancy amendment number 5, Jersey Law P8, lodged by Deputy Doublé. The main responder will be the Minister for Health and Social Services, and indeed the Health and Social Security panel, the chair of which is Deputy Lehegara. So there'll be two main responders, and I ask the greffier to read the citation.
Draft termination of pregnancy amendment number 2, Jersey Law 2000, a law to amend the termination of pregnancy Jersey Law 1997. The state, subject to the sanction of Most Excellent Majesty and Council, have adopted the following law.
Deputy Doublé.
Thank you, sir. The amendment I am proposing today relates to the termination of pregnancy law. This law was brought into force in 1997, and part of that law is a mandatory waiting period of 7 days before a woman can access abortion care after they first request it from their GP. The purpose of this amendment is to remove this mandatory waiting period and thus remove an unnecessary barrier to accessing safe and legal abortion care. I first became aware of this part of the law during the early stages of the pandemic. The UK were making adjustments to the way abortion care was administered to make the process as COVID safe as possible. I decided to check our laws to see what could be done. I questioned the Minister, Deputy Renouf, and he stated that processes around abortion pills being able to be taken in the home rather than in a clinic would be enabled in Jersey, as was happening in the UK. This was a reasonable adjustment, and I'm grateful that the Minister made it. However, as I looked further into our laws, I realised that the 7-day waiting period could also be a real problem during a pandemic. Currently, the process goes something like this. A woman has an appointment with her GP or with a doctor from the Labar Centre or Brook, Jersey, and requests an abortion. The GP has a duty under the law to provide her with certain information, including providers of counselling, opportunities for adoption, etc. This information is provided and a certificate is given to the woman to state that it has been provided. At this point, the woman is made to endure a mandatory period of 7 days before she can proceed with the referral from her GP. So let's just say a woman sees her GP on a Friday, even if there is a clinic on the following Monday, and it is my understanding that the clinics are held once a week. The woman would not be able to access this clinic because of the 7-day clause in the law. She would have to wait until 7 days had passed to be able to attend. And in practice, because the clinics are often once a week, this can result in a wait of longer than 7 days. If members approve this amendment today, sir, no medical appointments or other requirements would be removed from the law or from the processes of accessing abortion care in Jersey. The effect would be purely that when a woman goes to her GP and seeks an abortion, the GP is able to refer her immediately, and she can access the next available clinic without any additional waiting time. Of course, there is no compulsion to access the next clinic. If a woman herself would like to take an extra few days to consider her decision, then that is still fully within her capabilities. So it is quite clear, sir, that this clause in the law is problematic at the present time when travel is severely restricted and our laws only allow for abortion on demand on the island up to 12 weeks. A woman who discovers she is pregnant at 11 weeks and attends her GP will be forced by this 7-day wait to be pushed over the legal limit and therefore unable to access abortion care on island. Once I began to research mandatory waiting periods before accessing abortion care, it became clear to me that this was not at all best practice according to the medical evidence, even in normal pre-pandemic times. I will outline the reasons why. The first reason is that mandatory waiting clauses can act as a barrier to accessing safe and legal abortions. The World Health Organization guidance states that mandatory waiting periods can have the effect of delaying care, which can jeopardize women's ability to access safe and legal abortion services and demeans women as competent decision makers. So these waiting periods act as a barrier and a hurdle that women must cross over, and there is no medical reason. Few other medical procedures require such waiting periods, and there is evidence that it can be detrimental to a woman's mental health. The second reason is the statutory gestational limit that we have in Jersey. So there is no exception in the abortion law for an abortion on request on island once the statutory 12-week period has been exceeded. So if the first medical appointment takes place when the woman is, say, 11 weeks pregnant and the 7-day waiting period is in place, then there is no longer an option of having an abortion on island. Furthermore, there is only one clinic, and dependent on how busy the clinic is, or if bank holidays occur, there might be a wait for the second medical appointment. NHS UK states that abortions are generally very safe and most women will not experience any problems. But like any medical treatment, there's a small risk that something could go wrong. The risk of complications increases the later in pregnancy an abortion is carried out. So by forcing women to wait the extra 7 days, we're actually increasing the risk of complications. And if members could turn to the report attached to my amendment, you will see that members will see there is a table within that report. And that shows how the likelihood of complications from identical treatment methods can be considerably increased in the space of just 1 week. And so just to highlight one of these, an abortion at 10 weeks instead of 9 weeks carries more than double the chance of needing surgical intervention to complete the procedure. And there are other risks as outlined in that table. So, and the option of a medical abortion, which is using abortion pills, may be replaced by a surgical abortion if the pregnancy is beyond a certain stage. For example, medical abortions with tablets are generally only available in Jersey up to around 9 weeks of pregnancy, although this was extended to 10 weeks during COVID. Adding the 7-day wait at the key time of the 9th or 10th week of pregnancy could force a woman to endure a surgical procedure, a surgical abortion, completely unnecessarily. The third reason why this is important to remove from the law is that it can force off-island travel. So after the 12-week period is exceeded, so if a woman is pushed over that 12-week period by the 7-day wait, the only option available to her is to access an abortion on request is to travel off-island, usually to the UK. And this can often incur significant financial costs. In some cases is actually not accessible at all. It is also likely to cause additional stress and hardship, given that the medical procedure will be carried out away from home, family and friends. And as I've stated, this factor is especially pressing given the current limitations on travel. And the fourth reason I'd like to outline is cost. So if the 7-day wait pushes a woman over the 12-week limit and she must travel off island, the cost will substantially increase. So the on-island fee is £180. And not only would the cost of travel and accommodation be incurred, but the cost of abortion in the UK, which would not be covered by the NHS, is substantially higher. And it stands at around £450 to £700, depending on which clinic is accessed, and that doesn't include travel and accommodation. So members may be interested to understand how our legislation compares with similar jurisdictions. So I looked to the Isle of Man and also Guernsey. And the Isle of Man Abortion Reform Act came into force in 2019. And abortion services may now be provided during the first 14 weeks upon request by or on behalf of a woman. And in Guernsey, they have recently completely modernised their abortion law, and there is no mandatory waiting period between their consultations. And it's interesting to note actually that the Guernsey legislation changes have been highly commended by experts in the area. So to conclude, Sarah, it is clear that this would not be included in our legislation were we debating it for the first time in Jersey today. A mandatory waiting period could result in women undergoing surgical procedures or having to travel off-island unnecessarily, and it demeans women as competent decision makers. Approving this amendment would remove the 7-day requirement in line with international best practice. I propose the amendment, sir, and I ask members to support it.
The principles seconded.
Yes, sir.
Does any member wish to speak on the principles? A member wishes to speak. Senator Bezic.
Thank you, sir. I'll only speak very, very briefly, largely actually just to congratulate Deputy Doublé for spotting this issue and for, I think, making a very, very clear case for it in her proposition speech. Sometimes issues connected to abortion can be quite difficult debates when you see them conducted in other parts of the world. And I think that the case the Deputy made is pretty clear cut here. This is an important way of modernising these rules where they are out of step with how other jurisdictions treat this, but also I hope by what many of us would feel is just not an appropriate way of providing these services to women in that situation where this becomes necessary for them. So I simply wanted to congratulate the Deputy for bringing it forward and say that she has my wholehearted support, and I'll be voting in favour of this.
Very much, Senator. Deputy Swan.
Thank you, sir. As Minister for Health and Social Services, I likewise thank Deputy Doublé for bringing this matter to our attention and for our discussions we've had over recent months. And I'm pleased to say that I and the department support this proposed amendment. In doing so, I've consulted with our Associate Medical Director, who is lead consultant for obstetrics and gynecology, I've also consulted with Brook Jersey, the leading charity in this area, and family and home care nursing. And they similarly have no objection to the amendments. There are those issues which Deputy Doublé has raised, those potential catch-22 situations caused by the mandatory wait. My understanding is that no one in recent time has suffered detriment as a result of it, but still it is best to have our legislation to reflect modern good international practice. There appears to be no need to still maintain the 7-day waiting period. In contrast to 1997, when the legislation was introduced, there are now many sources of advice and information available to women who might be considering terminating a pregnancy. Therefore, sir, I am able to say that I would support the Deputy's proposition. Thank you, sir.
Very much. Does any other member wish to speak on the principles? No other member wishes to speak on the principles? Then I close the debate to call upon Deputy Doublé to respond.
Thank you, sir, and I thank the two members that spoke. And Senator Mesic, I thank him for his support. And it is indeed a potentially difficult area of debate, and I don't think I've ever been one to shy away from difficult topics. But actually, when I started researching this, the medical evidence is so compelling. I had no qualms about bringing it forward, and I hope that members will agree from my reports that the medical evidence is indeed compelling in terms of pointing us towards removing this today. And the Minister also mentioned international best practice, and I thank the Minister for accepting this today. And I note that he has agreed to meet with me. He mentioned that our legislation should be the best that it could be, in line with international best practice. So yes, I'm very grateful that he's agreed to meet with me so that we can look at the law in more of a broader sense, to perhaps pick out any other areas that need to be looked at. But this area, I feel, was the possibly the worst part of the law, which is why I decided to address it, alongside the fact that we're in a pandemic and the extra pressures that adds. Before I ask for a vote, so I forgot to mention that I have published a child rights impact assessment today on this, which is the first career that I have done on a proposition. It's quite a task, and only adds to the evidence in favour of removing this clause. Part of the evidence that was uncovered during that career was the high rate of sexual activity amongst teenagers and those in their early 20s, and it just adds weight to the fact that young people also need to access these services without unnecessary barriers. So I maintain the amendment, Sarah, and I ask for a vote on the principles, please.
Thank you very much, Deputy. I ask the greffier to post a voting link into the chat. And I open the voting and ask members to vote. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The principle's been adopted, 37 votes pour, 1 vote contre, no abstentions in the link, and 2 votes pour in the chat. And Deputy Tadier has asked for all the votes to be read out.
Those voting pour: the Deputy of St Martin, Deputy Gardner, Deputy Doublé, the Connétable of Grouville, Deputy Guida, Deputy Pamplin, Deputy Ward, Deputy Higgins, Senator Moore, the Connétable of St Lawrence, Deputy Lehegerin, the Connétable of St Clement and St Martin, Deputy Pinnell, the Connétable of St Peter, Senator Ferguson, Senator Le Fondre, the Deputy of St Juan, the Constable of St Mary, Senator Valois, the Connétable of St Brelard, Deputy Ayer, Deputy Lewis, Deputy Morel, and Deputy Southern and Deputy Tadier, Deputy Masson, Senator Farnham, Deputy Ash, Deputy of Grouville, Deputy Martin, the Deputy of St Peter, the Connétable of St Juan, Deputy Truscott, Senator Pallett, Senator Mezek, and the Connétable of Trinity, and the Connétable of St Saviour voted contre.
Very well. I am assuming Deputy Lehegerin, does your Health and Social Security Scrutiny Panel wish to scrutinise the matter?
No, thank you, sir. We're supportive of the legislative changes.
Thank you very much. Deputy Doublé, do you wish to propose the matter in second reading? How do you wish to do that? There are two regulations.
I do so, and I'd like to take them en bloc, please.
Well, are they seconded en bloc? Are they seconded for second reading?
Yes, sir.
Well, does any member wish to speak on any of the regulations in second reading? If no member wishes to speak in second reading, then I close the debate and call upon the greffier to post a vote in the link. I open the voting and ask members to vote. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The regulations, I beg your pardon, the articles were adopted in second reading, 39 votes pour, 1 vote contre, no abstentions in the link, and 2 further votes pour in the chat. Very well. Do you propose the matter in third reading, Deputy?
I do, sir, and I would just like to thank the Minister once again and his officers for the supportive comments, but also the stakeholders who I consulted with, which included the British Pregnancy Advisory Service, the Royal College of Obstetricians and Gynecologists, I think I said that right, and our own lead consultant for obstetrics and gynecology here in Jersey, all of whom were supportive. But I would also like to thank Rebecca Graham in the States, GREF, who heads up our research team. And as somebody who always likes to have a strong evidence base for everything that I do, my task was made a lot more pleasant and smoother than usual, having that resource available and also having resources available to help me with structuring the CREA. So I thank the GREF for providing that resource and for the officers in the GREF that helped me. And yes, I ask for the appel, please, for the third reading.
The law seconded in third reading.
Yes, sir.
Sorry.
And Deputy Pamplin.
Thank you, sir. Just very briefly, I think this is a really significant day by passing these amendments, and echo what Senator Mesic said earlier, and our current health minister. Waiting periods for abortion are common seemingly only in Europe and America, and there are none at all in parts of Oceania, like Australia, for example. And the most recent of these in Ireland are introducing a 3-day period. But if you do the research, which I'm sure members have done, and Deputy Dublay's provided quite a lot here, that many of previous research didn't reveal any mental health negative effects in countries that had these waiting lists. This is a really significant moment, and it should be applauded as we move forward. And as Deputy Dublay has outlined, and as the Health Minister himself agreed, contravening the World Health Organization guidelines. So I just want to echo that point, and this is a really important moment for this island, and congratulate Deputy Dublay. Thank you.
Any other member wish to speak in third reading? No other member wishes to speak in third reading. Then I close the debate and call upon the Deputy to respond.
Thank you, sir, and I thank Deputy Pamplin for his support, and I agree with what he says about impacts on mental health, and I believe now is the right time for me to ask for the appel, sir.
It is indeed. I ask Greffier to place a voting link into the chat. I open the voting and ask members to vote. If members have had the opportunity of casting their votes, then I ask the Greffier to close the voting. The law has been adopted in third reading, 39 votes pour, 1 vote contre, no abstentions in the link, and a further 1 vote pour in the chat. Very well. The next item of public business is the draft income tax payment of 2019 liability Jersey regulations, P9, lodged by the Minister for Treasury and Resources. The main responder will be the chair of the Corporate Services Scrutiny Panel, and I ask the Greffier to read the citation.
Draft income tax payment of 2019 liability Jersey regulations 2000. The states make these regulations under paragraph 23 of Schedule 5 to the Income Tax Jersey Law 1961.
Minister.
Thank you, sir. The States Assembly approved changes to the income tax law on the 4th of November 2020, which brought all Jersey taxpayers onto the same footing in the way they pay income tax. In 2021, everyone will be now paying income tax in the year in which the income is earned. This was a significant simplification of our archaic tax system, which will, later this year, considerably ease the next piece in the jigsaw of personal tax reform, which is the gradual introduction of independent taxation. This will, over time, see the end of so-called married man's taxation, when everyone becomes responsible for their own tax affairs, regardless of their marital status. The abolition of prior year basis and eventually married man's taxation will see us end a host of problems for islanders, including the problems that do arise when people sadly divorce with a prior year basis or current year basis tax bill, and when they are faced with big prior year basis tax bill in their first year in retirement. Moving all taxpayers to the current year basis, first mooted in the 2020 government plan, was accelerated because we recognised that by freezing 2019 PYB tax bills, we could help a large section of Jersey taxpayers who may otherwise be facing much larger tax bills this year and deductions from pay than they now will. It has served as a support measure for many of those hit by the pandemic and lockdown, particularly self-employed people. It has also served as a fiscal stimulus measure, keeping millions of pounds in the pockets of islanders. We originally estimated that at £18 million, but it now looks likely to exceed £30 million. That, to repeat, is money kept in the hands of islanders, particularly self-employed people who have been so badly hit during the pandemic. These regulations now set the terms over which the 2019 PY bills, which we suspended last November, will be repaid. So I undertook to bring draft regulations back to the Assembly to specify how former PYB taxpayers could pay off the 2019 frozen tax bills. The law we passed together last November obliges us to make such regulations by the 31st of March, the end of this month. I am grateful that members supported continuing with today's debate of the draft regulations, having been formally lodged one day late. I briefed States members about the detail of these regulations on the 22nd of January, and I am grateful to those members who subsequently raised issues with me, which I believe we have fully addressed. I am also grateful for the work of the Corporate Services Scrutiny Panel. I do not accept all of the findings of the CSSP report, which was published yesterday, but I will respond to that in the normal way in due course. I believe that their concerns about people who may divorce in future are particularly misplaced and fail to recognise very clear statements ministers have made in previous reports and existing legal provisions. As I said earlier, the abolition of PYB and married man's taxation will between them remove such anomalies from our tax system. However, I'm very pleased that the scrutiny panel has made two entirely reasonable amendments to the regulations, which do improve them and which I'm very happy to accept. So I will be proposing the regulations as amended. The draft regulations are based on feedback received from islanders in a survey last August, which drew responses from over 2,000 people. They were refined further in the light of feedback from focus groups held in October and from the review by the Corporate Services Scrutiny Panel. The payment terms have changed considerably from those originally proposed when we first went out to consultation earlier in 2020. Sir, these draft regulations provide two main options for paying the 2019 frozen tax liability. Option 1 allows former prior year basis taxpayers up to 20 years to pay without interest. Payment holidays are allowed if people's circumstances change. The effect of this payment plan is that most taxpayers would be paying a fraction of 1% of their total income during the period of those plans. Option 2 allows people to pay on retirement and is provided with those younger prior year basis taxpayers in mind who may still be in their 30s or 40s, bringing up a family and facing costs, for example, arising from school and university fees. Former prior year taxpayers need to make their choice no sooner than autumn 2022, when we expect to have systems in place to manage this procedure, and no later than the end of September 2024. Additionally, following lobbying from a number of states members, we have also made a special provision for existing lower income pensioners who may find those options unworkable to be able to pay from their testamentary estates where appropriate. Work now needs to commence on the detail to establish systems to record personal elections, manage payment plans, and handle the repayment of an estimated £350 million of frozen bills. Extra resources in Revenue Jersey of an additional 12 full-time equivalents, which is a 10% job increase. This is to support delivery of PYB to CYB, independent taxation, and to help clear the COVID backlog. The Treasury will give islanders more information early in 2022, and nobody needs to approach Revenue Jersey now unless they wish to pay off their 2019 bill immediately in one lump sum. So in this area of taxation, as well as others, making the transition from existing archaic tax arrangements to a new model is always complicated and presents numerous challenges for government and taxpayer alike. I believe the government, with the help of both the public and states members, have found a way through this problem, which not only simplifies our tax system and eases the passage to future simplification, but provides some immediate relief for many taxpayers who have been badly hit by the pandemic and by lockdown. So just for any ease of confusion, the amendments that have been accepted from the scrutiny panel do create an additional regulation which puts the original numbers slightly out of order. On that basis, sir, I ask all members to support these regulations. Thank you, sir.
Are the principles seconded?
Yes, sir, the seconded.
Any member wish to speak on the principles? No member wishes to speak on the principles?
It's working from the people are getting down to it. We are not.
Senator Moore.
Thank you, sir. I thank the Minister for her comments. I apologise to members that our report was not published earlier than yesterday, but I do hope that they have had an opportunity to take a look at it, to give it some thought and consideration, because it is indeed a comprehensive, constructive and thorough report. Once again, we have worked with an advisor, Rebecca Bennyworth, who has provided very important and constructive insight. So, sir, as the Minister mentioned, our report does make a number of recommendations, and I'm grateful to the Minister for accepting our 2 amendments. If the regulations are adopted today, a review will be carried out after 10 years to ensure that these proposals are performed well. And our second amendment ensures that provision can be made for people who experience a change of circumstances and need to seek to defer their payments of the 2019 liability. There are a number of matters that still cause concern. One is how the issue of the treatment of this change and how it will impact on divorcing couples. I do note the Minister's mention that she disagrees with our comments with regard to divorcing couples, but we stand by our comments, which have been thoroughly researched, and we have sought local legal opinion on this matter and found that it is a cause for concern. So we make also some other practical recommendations, in particular to the need to ensure that taxpayers can access a digital platform to manage and keep abreast of their repayments. The most concerning recommendation is our recommendation 8. Over the course of the past 2 years, we have regularly questioned the Minister and her team about the resources and training available to staff within Revenue Jersey. We've counselled the Minister to exercise restraint to consider her work programme in light of the capacity for the team that they have to administer it. This piece of work is no exception. Revenue Jersey has experienced severe problems. Public frustration at the difficulties they have in receiving advice or having their tax returns processed has been very clear. This change is yet another problem heaped upon the team, a team that has considerable number of new people who are not experienced with the Jersey system. And we again counsel the Minister to give due consideration to this matter. As we heard in my question earlier, people wait for months for responses to important questions. The media have covered a story with the controller asking people to not contact the office to help minimise the workload. And we heard there another message from the Minister for people not to contact Revenue Jersey about this matter. These are efforts simply to try to minimise the workload, but we perhaps suggest that if the Minister was more thoughtful in the bringing of various changes to the system, then it would ease the burden on this already pressured team. So these regulations do not meet the proposals that they set out to when the proposition was initially suggested and put forward to the public. And the ministers talked through the process that did see that the proposition as it came to the Assembly last year was different from that which was initially publicised. It's as a result of particular public consultation and the work of the scrutiny panel. We're grateful and thankful to the Minister for listening to those concerns and for adapting the initial plan, which was, of course, to repay a year's tax liability over a period of 5 years. Members will recall perhaps the debate of last year on this matter. The Minister had made considerable changes to the proposition, which, as Deputy Iyer said at the time, had been introduced in haste. Now that we've had an opportunity to consider the regulations and conduct further scrutiny, there has been an opportunity to consider the practicalities of the system that's proposed in these regulations. The advisor described the scheme as a high-risk strategy last year, and now I find that these regulations do not entirely achieve a sensible path for the reform of this issue. So I did vote for the original proposition last year, the principles. However, I recognise that at some point a move away from the prior year tax system is necessary. However, just because we need to do something does not mean that it needs to be done now, and we must give consideration to timing and the practicalities. Of course, some steps have been made to ensure that this is on the track. So this proposal, I fear, is on slightly shaky ground, and I would urge the Minister to take into account all of our recommendations, which I hope will go some way to improving the situation. And so I find that I cannot recommend the regulations, to the Assembly today. I can urge instead caution, and perhaps we'll listen further to the debate. Thank you, sir.
Very much indeed, Senator. Does any other member wish to speak on the principles? No other member wishes to speak on the principles? Then I close the debate and call upon the Minister to respond.
Yes, thank you, sir, and I thank the Senator for her comments. I won't respond to everything because we've done all this in scrutiny hearings, but I thank the panel, as I did in my opening remarks, for their report. which has considerable recommendations. The only reason I said that I couldn't agree with all of them, and the Senator mentioned the people getting sadly divorced, there is no difference to the change in PYB to CYB than what is happening now. If a couple get divorced in the year of their liability being due, the husband still has to pay it back and the lawyers sort it out. And that will not change. The husband is still liability, or spouse A still has liability for the 2019 tax liability. So, and that is sorted by lawyers, not by the tax department. So I don't really think that there's as much of a concern here as the Senator and the report points out. Obviously, in answer to her questions, the pressure on the revenue jersey, which has been pointed out in scrutiny hearings, and as I think the public are well aware of it, and apologies have been made by myself, by the comptroller, for the overwhelming amount of work. The phone calls to the department went up by 80% last year, and emails went up by 100%. Mostly, in fact, almost entirely due to COVID, because of the concern people had about their income. So they have been under pressure, and I recognise what the Senator is saying. But as I said in my opening remarks, Revenue Jersey have just recruited another 12 full-time staff in order to be able to deal with the pressures of moving this PYB to CYB and independent taxation, which I hope to bring to the Assembly in September. And in answer to her last question, I think all the recommendations that the scrutiny panel have put forward in their report will, of course, be taken into account, and our return report will be sent out in the due amount of time. And on that note, sir, I propose the regulations.
Ask the referee to place a vote into the link, the chat. And I open the voting and ask members to vote in the normal way. Members have had the opportunity of casting their votes. So I ask the greffier to close the voting. The principles have been adopted. 41 votes pour, 2 votes contre, no abstention in the link, and a further vote pour in the chat.
Can we have the two, please, sir?
People voting contre.
Those voting contre, Senator Moore and Deputy Morrell.
Senator Moore, I'm assuming your panel doesn't wish to scrutinise the matter as you've prepared a report already?
That's right, sir.
Very well, we move to second reading. Minister, you've indicated that you accept all of the, or both of the amendments from the panel. Is that the position? So do you wish to that the individual regulations are taken as amended?
Yes, please, sir.
Does any member object to the individual regulations being taken as amended? Deputy Young, do you wish to speak on whether they should be taken as amended or merely speak in second reading?
Yes, sir. I would like to talk separately, briefly about Article 11, please.
Well, no, that's right. We'll do that when we get to Article 11 in second reading. But if any member wishes to indicate we should not take them as amended, of course, each one can be spoken on in due course. Very well, then we will deal with them as amended. And how do you wish to propose them, Minister?
I'd like to propose them en bloc, please, sir.
Very well. Do you wish to speak to them, or do you wish to simply take questions on them?
I think that I can take questions on them unless anybody wants me to speak to them individually.
Well, I think that's a matter for you, how you present the regulations, Minister.
Okay, yes, please, sir. I'll just go through them, and then I understand Deputy Young wants to speak on 11, I think. So, Regulation 1 provides the standard interpretation provision. Regulation 2 applies the regulations to any person whose liability was deferred by the changes made to the primary law in 2020. Regulation 3 creates the default position that if no other regulation applies, 1/17 of a person's 2019 liability is payable each year from 2025 to 2041. Regulation 4 provides the right for a taxpayer to apply for payment holidays. A person's first application must be approved by the comptroller, but to prevent abuse, the comptroller has discretion as to whether to approve a second or further application. Regulation 5, as amended, provides for the ability for a taxpayer to be able to elect to defer payment of the 2019 liability until 12 months after they retire. The election must be made no later than the 30th of September 2024. Regulation 6 ensures that taxpayers who elected to pay in instalments can switch plans and pay after they retire if the comptroller is satisfied the taxpayer will have the means to pay. Regulation 7, as amended, requires taxpayers who are planning to pay after they retire to tell the comptroller if their circumstances change in a way that means they will no longer have sufficient means to pay after they retire. Regulation 7, as amended, also provides the comptroller with the power to request evidence from taxpayers to ensure they have the means to pay after they retire. If the comptroller considers they do not have the means, the taxpayer can be required to pay in instalments over the remaining period to 2041. Regulation 8 enables taxpayers to switch plans from paying after they retire to paying by instalment. Regulation 9 creates a special provision for individuals leaving the island. Any unpaid amount of the 2019 liability would crystallise upon their departure from Jersey unless they depart within 6 months of these regulations coming into force, in which case they have 6 months to pay. Regulation 10 makes a similar provision for non-resident landlords. If the Jersey property or properties are sold, the 2019 liability would crystallise when the taxpayer sells the property, unless they sell within 6 months of these regulations coming into force, in which case they have 6 months to pay. Regulation 11 makes special provision for pensioners who may face financial hardship. If the comptroller approves a pensioner's application under this regulation, some or all of the 2019 liability will be deferred to the taxpayer's estate. Regulation 12 clarifies that a taxpayer's death crystallises any unpaid 2019 liability. Regulation 13 ensures that the 2019 liability of trusts and estates are due and payable within 6 months of these regulations coming into force. Regulation 14 sets out special rules for partnerships by dividing the 2019 liability between the partners in the same proportion as the partnership profits. Regulation 15 provides powers for the comptroller to deal with taxpayers who choose not to comply with these regulations. If a person does not pay an amount due under these regulations within 3 years, the comptroller may demand payment of the 2019 liability in full. Regulation 16, as inserted by the panel's amendment, provides that no later than the 30th of June 2031, the comptroller must review these regulations and present a report to the States Assembly. Regulation 17 ensures that taxpayers are given the right to appeal decisions made by the comptroller under these regulations, and that appeals will be heard by the Commissioners of Appeal. And finally, Regulation 18 provides the standard citation and commencement paragraph. These regulations will come into force 7 days after they are made. I propose the regulations, sir.
Thank you, Minister. Are the regulations seconded in second reading?
Yes, they're seconded, sir.
Deputy Young, you wish to speak on one of the regulations?
Sorry, apologies, sir, to slow in unmuting and uncameraing. So I just wanted to start by saying I supported the regulations in principle. I've done that now twice, and I still do. I think, though, I am very, very grateful for the Minister and her officers who have spent a lot of time with me discussing with my reservations and concerns about the position of people, retired people, particularly those over 71. And of course, I particularly noticed in the figures published by the scrutiny panel just how much there are, quite a high proportion of the deferred liability will be for people who have already retired. I think what we were saying is 70 million is quoted as being over 65s, and I think it's about 20 million for the over 71s. I better declare an interest, sir, because I'm well into that group now. And so I think I'm hoping that I can just declare that interest. So, but I think I won't be alone in asking, raising the issues about. Obviously, life expectancy is limited. If we're lucky, we get our average term, but of course, it's almost certain that those of us in the age group, the odds are you're just not going to get the you're not going to pay the liability off before one's demise. And so the original version of Regulation 11, which was published when we approved it in principle, the one that was provided to members, provided that those in this category had the option to decide whether they pay it or whether they deal with the matter on their demise in their estate. And obviously what we've got now is, I mean, it's the Regulation 11, obviously it's primarily focused because of concerns over those pensioners that might have higher incomes and abuse it. And so therefore we've got this test of the controllers making a judgment about the circumstances, about the assets and all this kind of thing, and then potentially you know, a judgment which is kind of off the regulations. Now, obviously, it's absolutely right that the way it's drafted now, that we've got hardship provision for those in absolute hardship, and that's really good. But of course, there is a middle ground, and you know, that I concerned about that. I always did prefer two things really. I would like to have seen. And I discussed this with both the Minister and the Controller, and I accept it can't be done, but I still flag this up. I would prefer that those pensioners in that category who have pension funds could have used those pension funds and commuted them in a tax efficient way to be able to discharge this liability and get rid of it. But I understand that's not possible. The reforms of the tax pension just can't be done. They're too complicated. They present big problems. So having made those points, I'm not going to vote against Article 11, but I think I'm going to record an abstention purely for that reason, because I think we have no choice but to introduce these rules and these regulations. And I think I'm really pleased that we've gone from the 5 years to the 17. But I think I certainly hope the Controller, when there, because I've no doubt about it, that that these use their income to enjoy the rest of their life. That seems to be a reasonable thing, providing, of course, there are enough assets to discharge it. So I've just okay, well, I see that I've been lost. Very complicated business, but sir, I'm just saying.
No, it's all right. You weren't lost because of the complication, Deputy. You were actually physically, your transmission was lost for about 15 seconds. So
Oh, good. I'm
stop
relieved.
hearing
I
you
thought
completely.
I was speaking quite coherently, but maybe I'm not. But look, I accept apologies to members. This is quite a complicated business. I think the Treasury Minister and her officers have done as best they can, but I still think I still worry about the effects of those of us advanced years, well into their 70s, who may wish to push this liability onto their estate. So thank you very much. Thank you.
Thank you very much indeed. Does any other member wish to speak in second reading? No member wishes to speak in second reading. Colin Thompson-Wong.
Thank you, sir. I have a lot of sympathy with Deputy Young's views on this, but I have to say that a very thorough examination of the pension regulations was undertaken, not just at his behest, because I shared his concerns, but at the end of the day, I think we came to the conclusion, one, there were a number of technical issues in terms of changing the pension regulations to take out an additional cash lump sum over and above the 30% tax-free cash that anyone's entitled to. But also there are concerns about the pension is provided to give people an income to live off, hopefully for the rest of their lives. And if you deplete those assets at an early stage to pay a tax liability, if you are in a condition of financial hardship, at the end of the day, we, the government, end up having to subsidise that, because pension income could well fall away to a position where the pensioner couldn't look after himself or provide for himself financially. So on balance, I think the solution proposed by the Treasury Minister is a fair and equitable one, because although the people that inherit the estate of somebody who has to offer that up to as a surety for paying their the 2019 tax liability, at least during their lifetime they will have an income to live off, and is probably on balance the better solution. But I think I can assure members that we did go the rounds on this, not just with the Treasury Minister, but also I went the rounds with my team who look at pensions to see whether there was a possibility of doing this. But at the end of the day, I think that the balanced view was that actually it was best, this was the better of the two solutions, because quite a number of people will have uncashable assets such as houses, which obviously they're living in, and it makes it difficult if they have to sell a house. It's even more of a hardship for them to move out from their home than it would be to actually just say, well, okay, we'll just add this to our final estate when we die. It's the least painful solution for them. So it's a difficult discussion, but I think at the end of the day, pragmatically, we arrived at the right solution, and certainly I shall be supporting this.
Thank you very much. Does any other member wish to speak in second reading? No other member wish to speak in second reading? Then I close the debate and call upon the Minister to respond.
Thank you, sir. And as Deputy Young said, we have had many discussions on his concerns. Again, it's similar to the one I addressed over Senator Moore's question about people getting divorced. The current situation is not changing in as much as there's still a liability, and the liability still has to be paid. And the way people address it now is various. Some do leave it for their testamentary estate to pick up, which is not advised now, but the new regulations do permit that. And also a lot of people they have plans for paying off their prior year liability, which they will still be able to do. And the pensioners have always had to provide for their retirement to pay off the prior year liability. So we're not creating something new here. I think the whole idea, the regulations are far more generous and flexible than they currently stand. So I do think it's not a massive change. It's just that it is allowable to pay it over several years, up to 20, whereas before it was not. So I've had this discussion with Deputy Young, and I'm pleased that he accepts that we've got to where we are. And Conitard Buchanan also had discussions, and both of them questioned the pensioners' liability, and the pensioners' liability was addressed as to whether a lump sum could be removed in about 4 years ago. It was my predecessor, and it was a massive amount of work, and it was deemed that we could not, in everything that's going on, repeat that amount of work just 4 years down the road. So it has been addressed, and it was changed at the time. So that was the reason for it not being addressed in the concerns of the two speakers on this occasion. So I propose the regulations in the second reading.
Presumably you wish to take 1 to 10 first and then 11, because Deputy Young indicated a desire to abstain on number 11, and then after that 12 to the end.
Yes, please, sir.
Very well. The first vote then will be on regulations 1 through to 10 inclusive. There'll be just a moment before the graphic puts the link in the chat, so we can set it up to deal with it on that basis. Well, this is the vote on regulations 1 to 10. I open the voting and ask members to vote. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. Regulations 1 to 10 have been adopted. 42 votes pour, 2 votes contre, no abstentions in the link, and a further vote pour in the chat. Very well.
Can I ask for the two, please, sir?
2 votes contre.
Those voting contre, the Senator Moore and Deputy Morrell.
Very well, we come now to regulation 11, which will be taken separately. And I ask the greffier to put a vote into the link as soon as she's able to do so. I'll open the voting and ask members to vote in the normal way. The vote is on regulation 11. Members have had the opportunity of casting their votes. I ask the greffier to close the voting. The Regulation 11 has been adopted, 42 votes for, 2 votes contra, 1 abstention in the link and 1 vote contra in the chat. Very well. Now come to voting on the remainder of the regulations, specifically 12 through to 18. It's in the link, and I open the voting and ask members to vote. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. And regulations 12 to 18 have been adopted, 40 votes pour, 1 vote contre, no abstentions in the link, and a further vote pour in the chat. Do you propose the regulations in third reading, Minister?
Yes, please, sir.
Are they seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? No member wishes to speak in third. Chief
Yes,
Minister.
sir. Hang on, sir. Sorry, sir. I've got a slight echo. Mike, can you hear me okay?
We can hear you clearly, Chief Minister.
Okay, good. Thank you. No, sir, it was really just to commend the team that have got us to this stage, sir. The financial consequences of this are huge, as are outlined in the report, and not having it direct to hand, but it's over £300 million, so that will be generated as a consequence of this proposition. I will make the point, sir, that actually, certainly from my perspective, it started as a kernel, if that's the right word, of an idea that actually was a recommendation, I think, from the Corporate Services Scrutiny Panel. It was a scrutiny panel, definitely, in my time between whatever that is, 2014 or 2015, 2014-ish and 2018-ish, when we were looking, I think, at the MTFP of the day or the budget. And I can't remember how it was raised or when it was raised, but I know it was a scrutiny recommendation. And at that time, it was about funding future capital projects. Obviously, what this does, sir, is essentially puts us in an incredibly good place to deal with the COVID debt that the pandemic has generated, or the COVID legacy. So on that basis, what I would very much want to place on record is my absolute congratulations to the Minister, to her Assistant Ministers, and to the Treasurer and all of his team in bringing us to this stage. And I thank Assembly members for their support to date, and I hopefully they'll be supporting the third reading as well. Thank you, sir.
Much. Any other member wish to speak in third reading? Yes, Conor Wong.
Thank you, sir. I would just like to place on record my thanks to the Treasury Minister for resolving a problem that's been outstanding for some while. I think those of us who work in the field of retirement planning have always known that this is an issue, and that this is a sword that hangs over those people as they get closer and closer to retirement. And this, at a stroke, removes that problem from their planning thoughts, and I think gives taxpayers a greater degree of certainty when coming to plan their finances as they come up to retirement. I mean, one could easily say that, well, they should know about it and they should plan for it. But sadly, a lot of the time, life isn't like that. So I would like to put on record my thanks to the Treasury Minister for grasping this particular nettle. I think future generations of taxpayers who come up to retirement will be incredibly grateful, although perhaps some of them won't realise what it was like before this was on the statute books. So I thank her and her team. It's not been an easy bit of legislation, and I'm sure that the tax office is not going to find it an easy bit of legislation to administer. But at the end of the day, longer term, it's the right thing to do, and I commend her for doing it.
Does any other member wish to speak in third reading? If no other member wishes to speak in third reading, then I close the debate and call upon the Minister to respond.
Thank you, sir. And I thank the Chief Minister for his remarks. It has been a long road to get this far. Certainly, I've been dealing with it since I took office, but it was a long time before that it was brought forward that it should be removed from its archaic status and put into the future. I also thank Conitar Buchanan for his very kind remarks. And yes, it will be a lot of work, but as I mentioned in response earlier, that the Revenue Jersey have taken on extra resources to be able to deal with it. I'd also, whilst I've got the opportunity, like to thank the public for their extraordinary feedback in surveys and focus groups, States members also for their feedback, and in particular to the scrutiny panel, whose amendments, as you know, I have supported. And finally, a huge thank you for the massive amount of work Revenue Jersey, the Comptroller and the Treasurer and the officers have done in getting us this far. It is a very complicated issue, and to try and make it tenable for everybody, it's a lot of work. But I believe strongly that this proposition is good for the island and right for Jersey as a whole. So I commend it to the Assembly and ask for the appel in third reading, please. Thank you, sir.
Well, I'll ask the Greffier to place a link into the chat, and I open the voting and ask members to vote. Members have had the opportunity of casting their votes. I ask the Greffier to close the voting. The regulations are adopted in third reading, 44 votes for, 2 votes contra, 2 abstentions. Well, the next item of public business is the land transaction understanding order 1683 office accommodation project, Union Street St Helier deferral of approval, lodged by the Scrutiny Liaison Committee. main responders, I think, will be both the Chief Minister and the Minister for Infrastructure, who have asked me to permit 2 main responders, and I have agreed. And I call upon the chair to, I beg your pardon, ask the greffier to read the citation, the proposition.
The states are asked to decide whether they're of opinion to request the Minister for Infrastructure to defer approval of the land transaction agreement as proposed in the reports R19 2021 and R19 2021 addendum presented to the states by the Minister on 16th of February and 22nd of February 2021, pending the outcome of 1, a scrutiny review of the office accommodation project, which is to be taken as completed upon presentation of a scrutiny report to the states no later than 1st of June 2021. 2, the provision to the scrutiny review of the minutes of all meetings of the Council of Ministers, One Government Political Oversight Group and Regeneration Steering Group in relation to the project. And 3, a debate on a proposition lodged by the Minister subsequent to the presentation of the scrutiny report that provides for agreement or otherwise of the states for the Minister to proceed with the land transaction.
Deputy Young, you wish to speak in connection with the conflict of interest?
Yes, sir, please. Thank you. Although there is no current planning application on this matter, I think that we have a debate on a major states project where the states is the developer. Potentially my role as Minister of the Environment is in respect to the regulatory planning decisions. Now, I think it's inevitable there planning issues will arise in this debate, and I cannot rule out that I could have to decide some appeal. So, sir, with that, I prefer to withdraw from the sitting at this point and record that interest, if that's agreeable, sir. Thank you.
That's a matter for you, indeed, Deputy, so that's noted. And so I can't immediately remember who is making the proposition. Senator Moore, I'm so sorry, Senator, it just slipped my mind from it.
Not at all, sir. Thank you. Openness and transparency have been important themes of the past year. Scrutiny has been an essential part of that effort in the past year. We've assisted in overseeing and improving emergency legislation and many pieces of legislation that have come through this assembly. Scrutiny panels have been praised for bringing amendments to the Jersey Care Model, to the prior year tax arrangements, to the government plan, the hospital site selection and access route too. We've proven ourselves to be both constructive and proactive. Therefore, one would think that government should welcome our calls for a further look at this important project. It is true that there have been some confidential briefings for scrutiny members about various plans for a new office. Yes, we have seen some confidential papers, and yes, they have remained confidential. And those details, particularly the financing structure, varied from project to project. So, like many states members, and particularly many members of the public, when R4 was published and announced, this announced the intention to sign a contract for a site on Broad Street. This took us somewhat by surprise. We were even more surprised when that was withdrawn and replaced by R19, seeking a contract with a different developer on a different site and a different financing structure. At that point, scrutiny called for more detail to be published alongside R19, which saw a limited report published as an addendum a little later. So this is a major government project. Essentially, the proposal that is now on the table turns a public asset into a liability of something in the region of £100 million. It is quite extraordinary that the government would think it's reasonable to take such action without openly communicating it, is it not? And of course, we are all too aware of the other projects that are in the pipeline. A great number of people from all walks of life have contacted me and other scrutiny members in recent months to express their intense frustration and concern over the cumulative effect of these projects. Looking across the immediate capital spending plan, over £1.5 billion is planned to be spent, just as the island is starting on a road to recovery after a year of economic destruction and hardship for many. Far from being the sentinels of the old ways, as the outgoing chief executive might describe those who question his plans, the Scrutiny Liaison Committee understands the idea behind consolidating the office provision. But it has to question the process, the timing, the value for money that is being proposed. And that is why we're asking members today to delay the signing of contracts until a proper review is conducted. Capital projects are often a source of great interest in this Assembly. We have something of a track record, it's true, for arguing about the costs, the location and proposed uses of various sites around the island. It is, in a way, natural when we are so restricted for space. Capital spending projects are a matter of great interest to the public also. It's their money after all. The public cannot comprehend why this Assembly is signing them up to an unrestricted wish list of building. The restraint and prudence of generations who have put us in the solid position for today has been all but forgotten by this government. We already know that there's a hospital project likely to cost around £800 million. There's the integrated technology system, which has just called for an additional £20 million. And the minister responsible has declared in the media that he will just come back for more if the money runs out. Last week, they were told of the plans to spend £100 million to develop the sports strategy. We know there are plans to redevelop Fort Regent into a cultural centre that we've learnt recently. Although the cost of that project has not yet been revealed, it is rumoured to be in excess of £250 million. Next up, we hear that plans for a new ambulance headquarters is also on the cards. And there must be, or should be, plans in the offing for other much needed projects, such as the redevelopment of Rouge Bouillon School, the Youth and Community Centre that has often been talked about for St Helier. Will these be included too? If so, when? How much will they cost? And how will they be paid for? Jersey has always prided itself in being prudent and careful with public money. Yet there have been issues with that, and it would be correct to say that this preference for saving over spending has sometimes caused existing buildings to be allowed to fall into disrepair. The Chief Minister suggests that if this proposition is successful, it will cost the government £1 million a month. I would ask the Chief Minister to explain to the Assembly how and why this process can have moved so quickly in a matter of weeks as to make the public purse liable to such costs. The Chief Minister will recall that the Comptroller and Auditor General has made recommendations to governments previously urging them to avoid early contractual commitments which only serve to burden the Exchequer with liability for costs. Most of us here today would agree that an estate strategy is greatly needed, and we must deliver a coordinated plan to ensure that government is delivering value for money across its assets, delivering the best possible use of those assets for ensuring that it is meeting the needs of the public. An estate strategy is in draft form. From what I've seen of it, it is a high-level document that does not set out the necessary blueprint to reorganise, restore and prioritise the island's significant property portfolio. Without such a plan, it's important that scrutiny is allowed to conduct a formal review, and this matter should return to the Assembly for a political decision to be taken. This matter and the interrelated decisions will have a major impact for generations to come. It's of vital importance that we don't saddle our young with debt and leave them with buildings that don't meet the needs of the community. An estate strategy should also consider the question of sustainability and whether it is right to constantly demolish buildings that have suitable uses. It is time for the island to take sustainable building practices seriously. We've run out of sand. We experience high importation costs, which particularly impacts on products such as cement. There are plenty of methods available to improve the energy efficiency of existing buildings, and we should be leading by example. So this is a political matter, but politics is about priorities. Let's not forget the earlier attempt of this government to deliver an office. The government wanted to halt work at Ann Street days before Andium were due to start, and it took this assembly to tell them that that was not what we wanted to do. Well, today, I'm afraid, sir, is another opportunity for this assembly to direct the government onto a better track. Housing was, and it is, a priority of this assembly. We can all see the pain that the inexorable increases in housing costs have on our community. Look at any property website and it's clear that almost every property under £1 million is either sold or under offer. Look for a property to rent under £2,500 per month, and there is a race to snap up anything that becomes available. We've seen this week people queuing overnight to secure a flat in a new development. The pressure is causing families to consider moving to other jurisdictions in the search for a better and more affordable quality of life. This pressure is causing families, this pressure is causing people with much needed skills to reconsider job offers in Jersey when they learn that they would not be able to afford the space or quality of accommodation that they can enjoy elsewhere. Of course, this has, in some respects, been the case for many years, but are we not here to change that? To help those who experience housing poverty and the subsequent stress and health issues it can cause. I certainly campaigned in the election to help with those issues, and I would be failing the electorate if I did not remind the Assembly of this important matter. Members might be wishing for me to get back to the point, to focus on the development of this particular office on this particular site, but this is about more than just one project on one site. The chair of the Public Accounts Committee has announced her intention to review the estate's management portfolio, which has not yet been delivered. Therefore, the projects the government are announcing appear to be failing to take into account the bigger picture or to plan for the most beneficial use of the public's property assets. Indeed, if I may quote from a slide that was put in a presentation about the office strategy that was given to scrutiny back in October of last year. It says, if the wider estates programme is not planned and managed, then opportunities for disposals and to exit leases may be missed, which may mean that anticipated savings and/or capital receipts may not be realised. Well, one of the reasons that scrutiny has drawn the conclusion that we should conduct a review into the office strategy has been the events of this year. So far, as I described earlier, there has been confusion, changes from one bidder to another, from one site to another, and a deal to another. Then there's the scale and the cost of various capital projects that have been announced prior to an estate strategy being delivered. Why then is there such a hurry to rush into signing contracts with a bidder who only 2 months ago had been informed that their proposal had not been successful? Why would a delay in signing £1 million cause £1 million of costs every month when the government was thinking, what was the government thinking when they committed the public to such a situation? Indeed, constructive scrutiny is needed. So before I finish, I would like to address an issue that will no doubt be raised during the course of this debate. It has been argued, and the Chief Minister has indeed accused the Scrutiny Liaison Panel Committee of playing politics. If politics is about priority and prudence, well, I guess it is. But what this argument is not is an attempt to delay for delay's sake or to fit a populist agenda. It is becoming rather this argument, and I would ask the Chief Minister to find a valid argument rather than himself playing politics by trying to silence those who do not share his priorities or values. Disagreement is a genuine part of the political process, and it should be welcomed, so not chastised and kept at bay. The prevention of open, transparent and public discussion is common with oppressive regimes and has no place in the liberal democracy that we enjoy. So this debate is about protecting the public purse, ensuring a proper, open process has been followed and making sure that this project is necessary, provides value for money, and most importantly, that it provides a wide solution for government. Thank you, sir.
Right, Senator, is the proposition seconded?
Yes, sir.
Yes, sir.
Does any member wish to speak on the proposition? Deputy Lewis.
Thank you, sir. I will be voting against this proposition, sir, for the following reason. The idea of this project is not new. It's part of the estate strategy and will be a real opportunity to invest in our infrastructure. By moving forward with this project, we will provide modern offices that will support Government of Jersey staff. It will also provide our customer hub with the space and facilities they need to better serve islanders. This project will release several different sites to support the infrastructure of the island, either through vacating office spaces for new occupants or disposing of these sites. Vacating sites will also enable us to start to regenerate areas of St Helier for other purposes, such as retail and housing. With the potential, if we decide to purchase the building, to increase the government's book value of land and buildings by as much as £50 million. So regrettably, we have underinvested in our office estate over time. Some members have asked why not just refurbish Sir Lamocco House. Well, the building is too small, with a capacity for either 800 staff and limited meeting room capacity, or 650 staff with modern meeting room standards. It will not generate the revenue savings of approximately 7 million per year. It will reduce the capital receipts, 21.8 million down to 13 million. The poor condition of the building will incur additional capital costs of 25 to 30 million that are not in the government plan. The development risk remains with the government. Risks associated with planning permissions, and it will not meet environmental sustainability objectives. So I will now briefly outline to members the process I was required to follow in accordance with Standing Order 168. On the basis of the procurement and the preferred partner initially approved by the Council of Ministers, I signed ministerial decision for the Broad Street site. This decision was supported by procurement reports, full business case and regeneration reports that were shared with scrutiny. However, you would know that the changes to the tenders by the bidders meant that I could not follow through with this decision, so I retracted this decision. The procurement process allows for us to enter into negotiations with the reserve bidder in the event of things going wrong with the preferred bidder. So we did so. We sought relevant approvals from OneGov Political Oversight Board and the Council of Ministers, and on the basis of the initial procurement process, I signed a further MD to comply with SO 168 for the Union Street site. This decision was supported by the same decision-making information. There was no U-turn or sudden change of decision-making information. The changes proposed by the preferred bidder meant that we could not continue with the initial developer. However, we have followed the approved process, and the MD was supported by the same evidence and compiled with our obligations under SO 168. States members have been fully briefed and would be aware of the full details of the situation. However, some asked for additional information to what was made public. It is a balance between what can be said during a live procurement and what we need to do to comply with SO 168. However, scrutiny, states members have been fully briefed about the commercial aspects of the involving situation, and we have released what we can publicly. Sir, I hope members will join me in rejecting this proposition and supporting the government to move forward so we can begin to see the wider benefit of building the government headquarters and, most importantly, improving the working conditions of government employees. Thank you, sir.
Much, Deputy Conetable St Helier.
Thank you, sir. And I would like to start by commending Senator Moore for her opening speech.
I'm sorry, Conetable, to interrupt you. I see there's a point of clarification from Deputy Ward. Presumably that just got in a little bit late in respect to Deputy Lewis's speech.
Yeah,
sorry to defer.
Yes, so I apologise. When I go to put it in the message, if somebody has put something there, it covers it up, and it was just simply that. And I was trying to be polite and wait to the end of the speech.
Well, I'm sure we can treat that as made on time, Deputy Ward. And if you'd like to ask your point of clarification.
I just wanted to confirm from the Minister, because I think it's a very important point, as to whether we are saying, he's saying that this is not the original preferred bidder, and so therefore this is, if you like, the second choice bidder for this project. Thank you, sir.
Are you able to assist, Deputy Lewis?
Yes, sir. It's not the same project. It's a different project. The original project obviously was Broad Street, and the specification was changed by the original bidder, which did not fit in with our specifications.
So it's the second choice project, sir?
It is a different project altogether, yes.
Very well. Thank you very much. I'm sorry to have interrupted you, Conetable St Helier, but hopefully I did it earlier on. Sufficiently early. I call upon the Conetable St Helier.
Thank you, sir, and I'll repeat my approbation of the opening speech. I thought Senator Moore set out what I consider and what I hear from many members of the public, which is a lot of confusion and a lack of trust about how the government is proceeding with property in general. And as a member of the Regeneration Steering Group, I have certainly had concerns that what I consider higher priority matters, not just the delivery of affordable housing, but other public realm improvements which appear to have been cut back from the budget, have been neglected, while what I've called grandiose projects have steamed ahead, not just this one, but of course also Fort Regent and the Southwest St Helier master plan and others. So I have had concerns. I was also concerned when I asked on the group whether the parish of St Helier owned site, the Lampriere Street Yard, immediately behind Cyril Marquand House, was going to be part of this particular project. It seems to me to lack sense to have a surface car park right next to a major new redevelopment and to not seek to incorporate that site into the project. But having raised these concerns, I did get answers. I took advice from various people about the project, and certainly my concerns in respect of the parish of St Helier Yard, those concerns have been allayed by the conversations I've had, and I understand that there is certainly the prospect of that land being incorporated subject to parish assembly approval in a mutually beneficial way into the government building, if indeed it goes ahead on this site. Other concerns indeed about public realm investment, I've also been advised are being dealt with, and the Chief Minister has certainly encouraged me not to give up hope in terms of regeneration projects around St Helier. But actually, regeneration is a key word here, because in Senator Moore's opening speech, she mentioned the Anne Court debate, which was at the start of this government, and how long ago that seems now. It's ironic that she mentioned that, because of course what we were debating then was the provision of a good building for our public sector staff working in government. And here we are getting towards the end of the government's term, and I'm beginning to think now we are within we are within sight of actually achieving a decision to start work on a government building. That's not to say that's more important than some other projects, but it is important, having made the decision to co-locate our civil service, that we get on and find a building and we stop paying expensive rents in order to house them in private sector offices. The other point about regeneration, and I think it picks up the query, the point of clarification from Deputy Ward, is whether it makes a huge amount of difference to St Helier's regeneration, whether the government building goes in Broad Street, which was the first choice, the winner of the competition, or whether it goes on this site of the former Cyril Marcon House. And for my money, so they're both excellent sites for St Helier. They both, once people return to work and once people, I think, see the benefits of being a part of a collegiate enterprise rather than working in their front rooms and back rooms and study bedrooms, and they actually start to enjoy the experience of being part of a workforce again, I think it will be enormously beneficial for the town of St Helier, for the businesses of St Helier, and for the many businesses that depend on the workforce coming back to town. It will be vitally important that work starts on the government building sooner rather than later. And so at the moment, sir, much as I was impressed by the opening speech, I'm not sure that I've heard any really good reasons to stop work on this project and to delay it further. As I say, we were talking about it at the start of this particular government's term of office when we debated Anne Court being better, and we're still talking about it towards the end. And I think we need to make a decision. I don't want either myself politically or the states of Jersey generally to be remembered for delaying everything. Some things I think it is right to delay and to pause on, and certainly it's no secret that I've had major concerns about the way the new hospital project is being planned, particularly in terms of its access. But I'm not an expert on property deals. I'm not an expert on the financing and funding of public offices, nor am I really able to judge whether there might be a better location for a government building. I think the site of Cyril Marcon House does present enormous opportunities for this part of St Helier, which has suffered a depletion and a diminution of footfall with the concentration of business and so on in the southwest area and around the International Finance Centre and beyond. I think it's important we bring people back into the old town, to the vicinity of Parade Gardens, to the restaurants and cafes and other businesses in this area. And so I think to have a government building here, to have it well designed, will be of an enormous advantage, not only to St Helier, but also to the island, and crucially, to the people who actually work in the building itself. They will have access to Parade Gardens, which will be on their doorstep, and I think their experience of working in the new way that I'm sure we will be moving into will be enormously enhanced by the location that is currently being proposed. So on the balance of things, sir, I am minded not to support this proposition, but I will be listening to further arguments in the course of the debate. Thank you, sir.
Very much, Clontarf. Deputy St Mary.
Thank you, sir. I perhaps should have left my intervention until nearer the vote, but I wish to place on record my own position. I am a member of the political oversight group which oversaw the office accommodation project, and as such I approved or was party to the approval of the proposed site going forward. Equally, sir, by dint of my having been elected chair of the Economic and International Affairs Scrutiny Panel, I am now a member of the Scrutiny Liaison Committee, which has brought forward this proposition. But I wish to record, and I'm sure the committee wished me to record, that I took no part in any discussion regarding this particular proposition, absented myself from any debate, and for those reasons I consider myself conflicted, and I shall be abstaining when the time comes to vote. That is all, sir. Yeah.
Very much. Does any other member wish to speak on the proposition? No other member wishes to speak on the Senator Mezek.
Thank you, sir. I think it won't be too much of a stretch to say that most, if not all of us, would probably agree that the government has badly managed its property portfolio for many years now. I would hope that we would all agree that the government is operating over far too many sites, that some of the facilities that our workforce are having to work from are not great. At the start of this term, I was based at Cyril and Marco House, and it is a rubbish place to work. The layout is terrible, it's old and doesn't have great facilities. And so instead, we're now renting at great expense from the private sector an office at Broad Street, which isn't ideal. And I hope most people would agree that it's not ideal. And we have many sites still in our possession, which are languishing in quasi-ruins, not meeting their potential and not being used for some sort of public good otherwise. And I would also hope that people would agree that it is right that a government has a home that it can be proud of, that it has a premises where the workforce can be comfortable, can be working in a more collegiate way, under the same roof, to improve communication, improve ways of working, break down silos that often exist between government departments, and providing a proper front door for the public to access services. All of that is, I think, the right aspiration, but then you go beyond that and it's obvious that there are direct cost benefits from having that sort of facility, and it enables us to to empty buildings that can then go on to be used much more effectively. And when this project has been brought up, I've seen some commentary on it that I haven't agreed with. Some who I think come across as just believing that government spending any money is automatically bad, and who have this rather old-fashioned view that debt is automatically bad, when they don't realise that sometimes you have to spend money to save money, and that seems to be an important part of the argument behind this. And so I, for one, am absolutely supportive of a government office project that delivers that premises for the government to operate from and to be proud of, and serve as that focus point that I think is very important for a community to have. And so I'm not interested at all in backing any sort of wrecking motion. But sir, this is no wrecking motion. It's a motion to stop and figure out what the smell is before committing to something so big and with so much money attached to it. And I'm sorry to say, but there's something that stinks about this. We have a developer which we own, and we have lots of land which we own. And for some reason, we're being told that our own developer on land we own can't do it for cheaper than a private profit-making company using land it doesn't own. I'm sorry, sir, but I just don't buy it. I think there must surely be a catch somewhere in this. It doesn't strike me as giving confidence that the sort of deal we're after here really will be in the best long-term interests of the public. And I say that, sir, having in the run-up to this debate tried to do at least a bit of research into how governments in other jurisdictions have attempted to fund big projects where they've needed to build big buildings, whether it's a new school or a new hospital or office blocks to work from. And too much about this, to me, resembles some of the failed models that have been adopted in other jurisdictions. And in the States a few weeks ago, when I likened this proposal to a PFI scheme, I was admonished by the Chief Minister for doing so. And then a few days later, when we had a States members briefing, the officer who was doing the presentation there used the term himself to equate to what this arrangement is like. And so if we're going to sign up to something worth so much money where things could go wrong, I think it's right that there needs to be more done to demonstrate that we can have confidence that this will end up being good value for money. I want to know what sorts of risk we could be taking on if things go wrong. If there's a problem with the building, where does the risk truly lie? And if it is the case that the risk does truly lie with the private company that's delivering this for us, I kind of wonder why they're signing up to it. It wouldn't really make sense, and how they can make a profit out of it and still deliver it for better rates or as a better option than the developer which we own, that we can commission essentially to do whatever we like because we own them, and profit doesn't come into it because it's going from one government-owned budget to another. So, sir, I'm simply not convinced that the arrangement that the government have come up with is not different enough to what has been shown when it's been adopted by authorities in the UK as having bad value for money and often ending up the government tripping over themselves when they deal with some of the consequences of mistakes or problems with buildings further on down the line, to want to give a green light to that. It may well be the case that Cyril and Marcon House is the right space for it. I don't particularly have a view on that. I think there'll be lots of people who will be questioning why we couldn't use the site down at the Esplanade, which is due to have, which is open for us to put in an alternative application for an enhanced office space there to operate from on land we already own, when there'll be lots of private sector companies now questioning how much office space they actually use, and therefore potential question marks over what we can get out of that site for the private sector anyway. So I think to ask the Assembly to put the brakes on this for a short while so that that extra work can be done does strike me as reasonable. The Assembly is perfectly good at delaying things unnecessarily and not being capable of making a political decision, but I don't really think this is what some of the sorts of decisions that we've had over the hospital, for example, where some of those debates really have been unedifying. I think we do, I hope, mostly agree that we do need a proper government office space and that there are benefits that can arise from that. What we're talking about here is, from my perspective at least, a funding proposal that simply doesn't make sense, and I simply can't have confidence in it at this point, which is why I want that further work to be done, and why I would commend scrutiny for providing us the opportunity to allow them to do that work. And I think with the funny business that happened at the last minute, where there was apparently one proposal that gets withdrawn at short notice, and now we go for the second one, which I noticed when Deputy Ward asked for clarification previously about it being the second option, the Minister said it was an alternative option, which is, you know, there's some nuance in there that it's quite amusing watching ministers trying to get around. I would like to support this proposition, and I hope other members of the Assembly will, and I commend to the Scrutiny Liaison Committee for taking up this fight. If they hadn't done so, I'd have probably been tempted to do so myself as a backbencher. So I'll be voting in favour of this proposition.
The right Senator, Deputy Gardner.
And I'm pleased to follow previous speaker, and Senator Mezek touched on several points that I wanted to raise, so I will do my speech shorter. But I would like to start that at PAC, at Public Accounts Committee, we have received a presentation in October 2019. And in principle, I absolutely agree that it would be appropriate for the government of Jersey to build and hold its own offices, provided the cost is controlled and the building properly planned for the future. Lots of things happened between October 2019 and lodging R4 in January, which caught me personally by surprise. I also agree with my constable that office in any location, if it's Broad Street or if it's Parade or if it's IFC, will enhance St. Helier and bring more people and vibe into St. Helier life. Now, going back to my hat as the chair of Public Accounts Committee. Since 2018, we are asking from the government to publish a state management strategy. We all know that the state management strategy was accepted by Council of Ministers in December. I would like to ask Minister or Chief Minister why we still haven't seen the final version published. Not us, not public. The Public Accounts Committee is extremely disappointed and frustrated by the lack of progress in all aspects of estate management. For example, the Corporate Asset Management Board, a senior office level organization responsible for considering, prioritizing and effecting all decisions, requirements and capital project and funding issues across the government, hasn't been active as it's supposed to be active yet. And as a Public Accounts Committee, we are struggling to understand how meaningful decision can be made about any aspect of the estate, for example, office accommodation, where is no joint up approach. I understand that we can take this project and take it aside, and now I'm going to put my hat as a probably and ask, as we said, the change was within a week. So we understood from Minister's speech that we had only one reserved bidder. So basically we left without an option. When the bidder withdraw, the third bidder withdraw, we have only one to go forward. It would be helpful if Chief Minister or Housing Minister, I can see that he's going to speak after me, will confirm if they received concern from non-ministerial departments, and if these concerns were incorporated in the final decision to go forward with preferred bidder, because it's important to understand how we are bringing together non-ministerial departments, Moray House, and the government building, and if it's still the case as or not, which way it would go. Another question, and again, this is the common sense. I'm not expert in building offices myself, but from what I know from business, any commercial company which builds flat, even with the option to purchase, the landlord, in this case will be Dandara, will expect to make profit between probably 20 to 30%, maybe less, If it would be built by our SOJDC, our own government company owned by the Public of Jersey, would we expect the profit to come back to the benefit of the public? Has been this incorporated in the decision? Another thing, if you're looking through materials, any demolition of the house, the environmental impact is huge. And for years, we spoke that Cyrano Marco House, yes, it's old building, it needs renovation, but it definitely has another 30 years probably of the lifespan. Would it be appropriate to make it maybe into the flats? Again, I don't know. I'm not telling it's the right way to go. The only thing that I know, they raise lots of questions, and without having joined up approach across our estate management, these questions are valid. And last 2 points, the 100 million spending should be discussed within the state. We are taking huge liability going forward, but the state's members were briefed after decision was made. It's not that we've briefed the decision going forward. Without Scrutiny Liaison Committee bringing it into the debate today, the decision about £100 million liability, maybe a bit just less and just under, will go forward without any public debate. There is lots of confusion in the public and lots of questions from the state's members. And for me, this proposition, it's not wrecking proposition. It's propositions just asking to stop for 2 months, just above, understand what's happening, understand if it's good value for money, to understand what's happened with our Jersey owned States of Jersey Development Company. So stop and figure out and continue. I hope the decision will be made soon, and I will be supporting obviously this proposition. Thank you.
Thank you very much, Deputy Conitavos and Pralad.
Thank you, sir. I don't disagree with the principle of providing good conditions for government employees, but this in the wish that it is achieved without the questions surrounding the proposition for a Union Street building remaining unanswered. It cannot be right, sir, that we spend some £90 million without a detailed scrutiny report on the further detail of the proposed transaction. There is a public expectation that we do in scrutiny our job. There have been confidential details put through to some members, sir, but not all. And as was mentioned earlier, the sudden withdrawal of the Broad Street proposals for unclear reasons has given rise to concern. I suggest, sir, that challenge to policy is part of the proper democratic process and should be welcomed by the Council of Ministers, who give the impression of trying to be dictatorial in this matter. The cavalier level of spending is eye-watering, sir, and we must be given detail of how this will be funded and the effect on our economy. I urge members to support the proposition, which can only serve to give the government increased credibility. Thank you, sir.
Deputy Labby.
Thank you, sir. And if there's one thing I've learned since taking over as Housing Minister, it's that, and one message I want to run with and results I want to get, it's that we are not telling our housing providers early enough which states-owned land they're going to get for housing development. And it's been especially bad during the uncertainty with where the hospital is going, and that's held things up. And that looks, the end is in sight, we think now for that. And if we have uncertainty again now on where the state's offices are going, that is again going to hold things up. But every time there's a block or there's uncertainty, this bizarre game of musical chairs in terms of where bits of state-owned land are going to end up, that bizarre game stops and is held in suspension, and that is not good. Look, we have La Collette Low under construction and Anne Court under construction. And there are plans for 1,000+ units from Gas Place down to Green Street, with the Limes, the Mayfair, the Apollo, Kensington, Gas Place, but none of those, Ann Street Brewery, None of those have planning permission. They're in the pipeline, but they don't have planning permission. And if there's problems, as we have seen there has been with the gas place, this holds thing up. The pipeline for housing coming online needs to stretch further into the future, even 5 or 6 years hence. So we need to tell Andium or SOJDC or the Housing Trust, but specifically Andium I'm talking about here, we need to tell them that in 5 years' time, they're going to get the site of the Le Cannevet School. Depending on, there might be other things that need to go on there as well, but if there's going to be a housing component of whatever percentage, we need to tell them now so that the planning process can be undertaken. Everything, the architects can get to work, everything can be done so that it's ready to go when the land is available. And if we can't tell them now that they're not going to get Le Cannevet in 5 or 6 years when health decant back to Overdale, we need to tell them and they should look elsewhere. The same is true of the Le Bar Centre. The same is true of Lamott Street. Holding up this government building, the new government building, is going to cause uncertainty. It's going to prevent me from being able to get government to hand over those sites or let Andium and the other providers know they're going to get them. And that is going to prevent us delivering the houses that we need to deliver by 2030, and especially the affordable houses we need to deliver. It's that stark. I think this is a good building. It's a very handsome building. It's right for its site. The current Cyril and Markle house architecture is a criminal waste of the footprint it sits upon. And this is a much better use of that resource. And it's not just a government building for civil servants and for ministers. It's going to be a public building, and a really good one. And it's an impressive civic building that we've seen the plans for, and the public will have access to it. I think that the Crown Office, the law officers, and the Gref have one argument that they should stay in Murrier House, especially the law officers should not be in a government building. That physical separation is important. I believe that they've won that argument. That then frees up some more space in the proposed new building for what I definitely think we are urgently in need of, which is the kind of hearing rooms and committee rooms you see at those of us who've been fortunate to work in Portcullis House in Westminster. You know, the rooms designed for public hearings, the planning committee hearings, scrutiny hearings, where everyone has got the right place to sit and see things and access, and can be live streamed as well. I mean, we are wondering, you know, we're going from the museum down to the St Paul Centre, or fitting into those 2 rooms in the States Building, which are not fit for purpose for that important scrutiny work and the other hearings that we have to do. And that I would like to see in the new building. And it's very possible that lots of what happens in Lamott Street now will happen in this new building too. So it's important that it's not just seen as something that is exclusive to those working in government. And you know, what has always worried me as PPC chair is members meeting constituents or people alone sometimes in the States Building with no reception. I've always been worried about that, and I think the new building should have a facility a reception, and for security purposes, it's important too. And the Constable of St Helier is absolutely right. Decanting everything to the waterfront is going to leave a very dangerous vacuum. 1,800 civil servants in this building, in this part of St Helier, is good for this part of St Helier. We don't have a staff canteen in these buildings. They come out to the central market, the restaurants, the coffee shops. It's very, very important that they're kept here. So this is not the time to put the brakes on this. I do appreciate, I hugely respect Senator Moore and the scrutiny function, and I understand, but now is not the time to put the brakes on. Now it's time to accelerate for delivery of housing, if nothing else. Thank you, sir.
Thank you very much. Deputy Senator Ferguson.
Thank you, sir. The transaction being planned, I haven't got all the information required to comment on this in detail, but this does not appear to be the same sort of public-private financing that Gordon Brown and his Labour Party people supported. That was one where the financing of the services, cleaning, maintenance and other services, burdened the buildings with excessive costs because the private developers hung on to those and actually sold them into investment trusts being held in Guernsey. But there's a difference. I've also heard comments about, Cyril Le Marchand House. We don't need to, it's a perfectly good building and we should either convert it into housing or renovate it. I'm sorry, I worked in that building for a considerable time. It was poorly designed and built and not at all pleasant in which to work. And Cyril Le Marchand actually hated it. If he had lived, I don't think the States would have bought it, but that's another story. If you wanted air conditioning, you had to open the windows on both sides of the building. And the corollary to that was there really wasn't any heating in the winter. It wasn't very effective. I agree entirely that we need to co-locate all the state's departments except, as mentioned, the law officers and so on, into Cyril Le Marchand, and we will free up sites all round the St Helier, and we'll provide a convenient centre for people to meet with officers. There are queries on the financing side. Well, I'm quite certain that an explanation to the scrutiny panel, I presume they've had a lot of information already about it, but this is something that can be arranged between the Chief Minister's Department and the scrutiny panels. So I think we should push on with this, we should press on with it, because we cannot afford to have so many civil servants scattered all around the town. Thank you, sir.
Thank you very much, Senator. The Connétable of St Mary.
Thank you, sir. The most important issue in this island at the moment is the commencement of our new hospital and all that goes with it. The next most important issue facing people in Jersey is housing, whether that be rental or first-time buyer. If we want the best people working for Jersey, they need housing. And of course, wherever you put housing, drainage and fresh water is required. Many sites across the island are unsuitable for housing due to lack of drainage and fresh water. It's a catch-22 situation. Many people in this island are denied these basic facilities now, and that needs to be addressed. In order to make this island as efficient and self-sufficient as possible, money has to be spent. Money which we don't have. Now is the best time to borrow money for these projects, and it makes sense to provide the most up-to-date government office that we can provide in order to lead those and other projects. We cannot run this island piecemeal. We need to have many irons in the fire. I will not support this proposition. It is important that we move forward as soon as possible in providing a government building. We need more detail, but the principle is the right one. Thank you, sir.
Very much, Connétable. Deputy Pinnell.
Thank you, sir. And I hope this just might provide a little more clarification for States members on the detail the previous speakers have asked for. The procurement process was open to all. It was published on the Channel Islands tender portal and the official journal of the European Union. The procurement strategy was approved by the One Government Political Oversight Group. It clearly set out the ability to nominate a reserve partner, which is standard practice. My understanding is that the procurement strategy was shared with scrutiny in spring 2020. There's been no change of tack or quick decisions. We have followed process, and this has been done in public. We have followed the Public Finance Manual. And clearly we can't comment further on a live procurement. Both final shortlisted bidders submitted final tenders that met our requirements, and both were evaluated as part of the full business case. This project will save approximately £7 million per annum, for example, with operational costs and capital maintenance. It is an important project to deliver efficiencies that will enable other ministerial priorities to be funded. It is part of a balanced government plan, which has been approved by the Assembly. Across the estate portfolio, capital receipts of circa £22 million will be raised from disposals and congregating the whole of the civil servants in one headquarters. The financial implications of any delay of the project would be in the region of circa £1 million per month prior to being contractually binding. If the procurement fails, we will experience abortive costs of the procurement, so far of circa £1 million, and may also receive a challenge for costs incurred by the bidders. Thank you, sir.
Unless any other member wish to speak on the proposition. Senator Balwa.
Yes, thank you, sir. I want to speak, I think, predominantly listening to particularly the Housing Minister's speech, and everything he talked about was fairly correct. However, what he was talking about should be seen openly and transparently in an estate strategy. That estate strategy, even though the minister, when speaking, stated that this was part of an estate strategy, nobody has seen that in the public domain. Nobody understands how that fits into the estate strategy. Nobody understands how a significant value of a contract such as this for office accommodation aligns with that estate strategy, and therefore does the things that the Housing Minister was referring to in terms of ensuring that we free up public land for things such as a priority of housing for the island. I've had a number of members talking about playing an uncertainty card and talking about, you know, that there was always going to be a risk of being accused of delaying something by bringing a proposition like this. But this proposition is a legitimate use of procedure within our democracy. There's a very reason why we have Standing Order 168, sir. And although it keeps on being mentioned, and I'm sure will be mentioned plenty of times again, particularly from ministers, that scrutiny have received strategic outline cases, that scrutiny have received briefings. None of that was particularly in the public domain. And there will be arguments around commercial sensitivities, which are totally understandable. But a predominant part of that is why it is important to have such a thing as an estate strategy, something that the Comptroller Auditor General has recommended a number of times, whether that's throughout the Lime Grove fiasco we saw 8 years ago, or whether that was throughout the piece of work on operational land and buildings. There's also the issue of how limited our own arm's length company is in terms of States of Jersey Development Company with regards to contracting for procurement over something like an office building or any other property deal that the states wish to go forward with, or the government wish to go forward with. And that's because of the risk limitations that we place upon them. Quite rightly so, some would say. That proposition was debated 11 years ago, establishing the States of Jersey Development Company. And maybe there is an agreement or something that needs to be said about how we look at that going forward, talking about regeneration of St Helier, as the Constable of St Helier referred to. And with regards to delaying what is being suggested here, if members read the report of the proposition, they will identify that when the strategic outline case was put to scrutiny and to members back in 2019, it was suggested within the timeline that the contract would not be signed until May 2021. It really does fail me, sir, and the Chief Minister will be completely aware and concerned as well at the fact that we don't have an alignment around our property strategy, around an estate strategy that aligns all the many things that have to line up to ensure that we're spending our money in good value on behalf of the public. And when I say our money, it is the public's money. And when we talk of savings of 7 million per annum, which the Treasury Minister's just referred to, yes, that's brilliant. But in contrast to the amount that we're spending on the overall property, is it really a saving? And will it predominantly mean, because the work has not been scrutinised as closely and as effectively as it could be through the scrutiny process, and I want to remind members, scrutiny is not opposition. Scrutiny is there to support and assist on behalf of the public to improve policy and legislation. The Constable of St Mary's refers to a principle, that this principle is the right one. Yes, it may be the right one, but we are not agreeing the principle, sir. We're determining whether we're utilising an appropriate democratic procedure that's in place by this Assembly as to whether signing up to a significant value of a contract for states officers is the right thing to do without the open, transparent assessment or scrutiny of such a process, and without an estate strategy, which I believe, if we're going to put a cart before a horse, I think this very much defines that situation that we're finding ourselves in now. I think if we'd had an estate strategy and we understood that and we were aligned to that and signed up to it, it is not good enough to say that this is part of a balanced government plan. In a question earlier today, I asked about what was in the government plan and infrastructure fund. We may see that this year, and that may be part of the estate strategy, but we don't know. So, sir, with regards to signing up to a contract such as this, and having worked on public accounts committees and corporate services and within Treasury itself over my time in the States, I think it's untoward of us to suggest that we're trying to delay, or we're trying to say that this isn't the right thing to do. What we're saying is allow the process to go forward in a democratic, open, transparent and responsible way. So on that basis, I find myself having to support the proposition, because I feel that considering all the work that's been provided to scrutiny in a confidential manner, it is difficult to then go forward and carry out that review in the manner in which scrutiny does their work, particularly with regards to the changes that we've seen earlier this year when R4 was lodged by the Minister for Infrastructure and then repealed, and R4 didn't have sufficient information in that. And then R19 came forward with a completely different plan. And That may be legitimate as per procurement processes. It may support what is being suggested by the Treasury Minister, the requirements around the Public Finances Manual. But sir, we just don't know whether that's the case, do we? Thank you.
Thank you very much, Senator. Connie Tarbison.
Thank you, sir. Can you hear me clearly?
Yes, we can, Connie Tarb.
Thank you. Ever since I've been a member of the States, I have to say, as somebody who's come from a commercial background and used to working in relatively modern offices, I've been sort of horrified by the conditions that we ask our staff to work in. And having looked at the States building, and obviously as an islander, I've seen what's happened. We have significantly underinvested in our office estate for quite a period of time. And I'm not going to get into the weeds of what scrutiny were told or what they weren't told. But certainly from the chronological list of briefings that I've seen, there seems to be an awful lot of information that's being provided. But to me, commercial opportunities don't wait forever, I'm afraid. And this deal to me seems to be particularly good. Here we have, and I accept that the previous bidder was also a good deal, but unfortunately, because they changed the bid, we were unable to go with them. And that's perhaps a shame. But anyway, this particular deal seems to be particularly good because the developer is offering to fund this deal and giving us an option to buy it back for any time after 3 years. Now, Senator Mezek asked about the commercial realities of that. Well, I think it's quite simple. The rental yield is obviously going to be quite attractive to the developer. And also for a government such as ourselves, particularly strapped for cash at a time of COVID, this represents a good option for us. But I think, in my view, this represents an opportunity to, we've talked a lot about state strategy, but to me it seems to be fairly simple. We want to get all our people into one building as much as we can, given what they do. I mean, except the police and fire might be a different equation. But it's important, I think, to get everyone under one roof. And this, to me, represents a very good opportunity to do that. But I think if we delay, I think there's an opportunity that opportunity may well disappear on us. And I can't actually see what we're going to get back from the delay. We know what the heads of the deal are. And from a commercial, if we were working in a commercial world, we would just get on and do it. And I understand the need for democratic accountability and transparency. But I think in this instance, it seems to me that we have asked all the questions, perhaps some of them in private, and most if not all the answers have been provided. So I for one, think that we just need to get on with this, and we need to get our staff into a situation where they're working in good conditions. And we need to give them the opportunity to network together and to have decent offices. Because as we keep stating, we want to be the employer of choice. And one of the factors when choosing an employer is what premises you're going to be working in. And if people are being asked to work in substandard premises, then it weighs in their mind when they make the choice to come to us. And there are certainly other large employers in the island who have much better premises than we do. So I, for one, am keen to address that issue. So I find myself unable to support this proposition. And I think we need to think very carefully about the way forward and the speed with which we need to do this. And given that we're not being asked to put up a lot of money up front, and it will save us money on other properties, and it gives us the opportunity to develop our other properties for other purposes, I think we just need to crack on with this and do it. So I, for one, will be voting against this proposition.
Much, I'm noting in the chat that there is quite a lot of suggestions that we might adjourn. It is obviously now not 5:23, and that's 7 minutes before standing orders requires me to raise the issue of adjournment. But if someone wishes to propose the adjournment, then there is no reason why that cannot happen.
So, before I do so, I just wondered if there were any other members wishing to speak other than some deputy of St Martin, sir.
I have no one listed to speak at the moment.
There are plenty queuing up, sir.
Okay.
I guess that there might be, but
I propose, sir, we might get one more speaker in and then adjourn at 5:30.
Well, I think we have to invite someone to speak, and then if someone wants to move the adjournment after that, then that's a matter for them, Senator. But I don't think we can.
So may
point.
So may I say the government did ask for 2 main responders and only 1 has spoken. So this
Yes.
debate is obviously going to go on tomorrow, and to have somebody have to speak now, right at the end of the day, I think be more effective for a debate if we were to start again tomorrow.
Well,
Personally.
Deputy, it's entirely open to you to propose the adjournment now, and then members will adjourn or not, depending upon their point of view. It's not for me to decide. I'm in the hands of members.
Of course, sir. Thank you, sir. Then I'll propose the adjournment, please.
And I'll
second.
Seconded.
And seconded.
Yes, sir.
Seconded. Does anyone not wish to adjourn? If they could indicate, and then I can throw the matter open for debate if necessary. But perhaps someone could indicate if they wish to be a debate on this. Otherwise, I'll simply take it as a standing vote. No one has indicated that you don't wish to adjourn, Deputy Morrell. Yes.
That's correct, sir.
Would you like to speak?
6 minutes left, and there's time for another speech. Somebody has to have the last speech of the day. So, you know, I think we should just continue until 5:30 as we ordinarily would. I don't understand the clamour for finishing 5 minutes early. Thank you, sir.
Well, it's a proposition duly made. Does any other member wish to speak on the matter of the adjournment? No other member wishes to speak on the matter of the adjournment. Then
So can I reply to that?
Yes, but I've got to close the debate first.
Of course, sir.
Any other member wish to speak on the matter of the adjournment? If no other member wishes to speak, I close the debate and call upon Deputy Ward to respond.
So I fully understand what Deputy Morrell says, and to a large extent I agree with him. But I think too often we play sort of games of chicken and who's going to speak last, and it's at the detriment of debate, because this is a really important topic. People may want to speak for longer. People may be leaving the assembly at 5:30 for whatever reasons, and we have said that what we would do in the future is finish on time. In addition, sir, we have very little after this apart from the in-committee debate, so we will be back tomorrow anyway. And I think it's a much more effective and thoughtful use of our time if we come back when everyone's fresh in the morning, go back over this information, and then give Senator Moore a decent amount of time to respond as well, which is fair, given that the government have 2 main responders. So I would ask the Assembly to vote for the adjournment now, and then we can move forward tomorrow as effectively as possible. Thank you, sir.
Thank you very much. I'll ask the Secretary, I think, to put a link in for voting on the adjournment. The proposition is that we adjourn now until 9:30 tomorrow morning. I open the voting and ask members to vote. Members have had the opportunity of casting their votes, and ask the Secretary to close the voting. The proposition to adjourn has been adopted. 35 votes pour, 4 votes contre, no abstentions in the link, and a further vote pour in the chat. Very well, before I formally adjourn the Assembly, after this matter of public business, the last matter of public business is the in-committee debate. That has been scheduled to start on Thursday morning. We will, I think, have to take a view tomorrow, depending upon how long this matter continues, as to whether we continue with it tomorrow, whether we take the in-committee debate tomorrow or in Thursday as presently scheduled. So members might wish to reflect a little bit on that overnight. My instinct would be that if we finish this tomorrow morning, if it is early-ish, we move straight on into the in-committee debate and take the rest of the day, or alternatively, if it's closer to late morning, we take a break and then start and do the afternoon, the in-committee debate following on the following morning if necessary. But those are preliminary and provisional thoughts, and I'm not suggesting that that is certainly the way members might wish to deal with the matter. But food for thought overnight, and the state stands adjourned until 9:30 tomorrow morning.